we are going to follow very closely to this letter that came out on Friday evening from Judge Merchan to the Trump and to the Trump legal team and to Alvin Bragg's team about this Facebook post. As I explained to you, I think it opens is not just is this person directly tied to an individual who's on the jury as they claim to be a first cousin of, or if it's just some kind of internet troll. It's opened up now the court to give them an opportunity I think they must take to put every juror on under oath and bring them in and ask them a series of questions. And the question one is not, do you know Michael Anderson? Is that a cousin of yours? You could eventually get to that, but it's really not important, that name. What this opens up the ability to question is, did you speak to anyone you were unauthorized to speak to about the verdict in this case the day before the verdict came out, or at all during your deliberation process? And if a juror or multiple jurors raise their hand because they are under oath, guess what? You've got grounds for a mistrial, and this comment really just led us into allowing the court to open up that investigation. So you see how you could take something like this that officially came from the court, and the questioning doesn't have to start with Michael Anderson in this specific post. The questioning should start with, did you violate the rules of being a jury member? We know these jury members went to their dentist appointments. We know they went to their doctor's appointments. We know they went home at night. They were not sequestered. They lived as much as possible their normal life during this process. They went about it in a normal way. It was 6 weeks long. But the fact is, this comment that was made is made 2 days after they go into jury deliberations and a day before the verdict is released. So the court, again, the step is not, do we just confirm that this statement really came from someone's cousin? The first step is, did any of you jurors speak to family members or other people who you were unauthorized to speak to about your deliberations and the likely outcome of this trial? Because there, you could have multiple juror members raise their hand and say, or while they're under oath, and say, yes, they did. Now, you might have none, and we might not have enough here to then move forward with a mistrial. And we always want to be honest with you about that, the ACLJ. But it now puts this burden on the court to maintain its appearance of fairness and relevance. I mean, I think you have to have that investigation. Well, if you don't ask those questions, this is going to dog them for the rest of the trial.
That's right. And as Arthur on YouTube said, the whole process was a sham and should be thrown out by the appellate court. I think that when you see these issues that keep arising, whether it be the jury instructions, whether it be not allowing the FEC commissioner to testify because the judge is the only one allowed to talk about the law in this case, whether it be the scheduling of the jury and allowing for early days for dental appointments and things of that nature, it to some degree makes you question how serious the judge took the case. Right. When it was such a high-profile case that should have been taken very seriously. And when you see this, you say, oh, great, he sent a letter, he's taking it seriously. But if the court doesn't do anything to follow up on this and to ensure that this wasn't grounds for a mistrial, if that is so the case, or if it is grounds for a mistrial, that they take it to the steps that are appropriate and take it seriously. And right now, I think looking at our audience and looking at really the way that I feel most people feel, you really question if the judge does take it serious enough, but we'll see also, if he doesn't, what the appeals court does.
Let's go to Donna in Colorado on line one. Hey, Donna.
If the judge does call these people back, and based upon the instructions he first gave them, he might not even couch the question in a way that gives them the opportunity to say yes or no. If they all say no, if they went to the dentist or they went to the candy store and they say they didn't talk to anybody, is this post now moot? Does it have no weight at all that anybody can use?
I think if you went to every jury member under oath and they said no, and you had no other evidence, I'm not sure, Will, how else you proceed with that. If every one of them said, no, I did not speak to anyone outside of who I'm allowed to, which is inside this jury, about our deliberations or about the verdict that we are going to announce.
Right. But I also think while it may not lead to something like a mistrial, I do think it does give another arrow in the quiver of the defense team as they go into the appellate stage of the unorthodox way this entire case was handled. Now, that may not be the pivotal piece of evidence of even look at this, but it could be just one of the pieces that give them a robust defense when it comes to an appeal process. But once again, that could take a while, and we'll see how that plays out. And let's go to Mark calling from South Carolina on line 3. Hey, Mark. You're on Seculo.
Hey, guys. I really appreciate what you do. So as far as I know, the jury was not sequestered. I don't think it matters if someone talked to a cousin or not, because they weren't sequestered. They deliberate. Some of them may be on the fence as to whether they're going to vote guilty or not guilty. They have access to this Facebook page, and they see that comment, and it sways their vote. Why that Facebook page isn't monitored and scrubbed on a daily basis is beyond me. But I think there's real grounds just on that basis, and I think that entire court case was sloppy from beginning to end.
Well, and Mark, one of the interesting things here, because MSNBC immediately called it a debunked post. CNN said, we don't have all the facts here yet, which is true, and that's what we're saying. But the media rushed to try to discredit it.
The story.
But what I think is interesting is that this person described himself as a professional troll. He used more colorful language, but as a professional troll. That doesn't necessarily mean he's not telling the truth in this situation. But also, if he were a professional troll, I feel like he would have gone to a more high-profile place to actually post this than going to the 4th department of the appellate division.
You're hiding the comment about this within a Facebook page. Let's just be honest about it. A Facebook page that so far, under the post of where it was, had nothing to do with the Trump trial. Nothing at all to do with the Trump trial.
Cindy's watching on Rumble. Welcome to Seculo. You're on the air.
Hey, Cindy.
This is a hypothetical. I'm not an attorney, but I think how the question would be posed to the jury would be very important, because if I'm having a conversation with a juror and I ask them if Trump will be found guilty, maybe they didn't verbalize that, but it could have been, a wink, a nod, a thumbs up, that kind of thing. So how they pose the question, do you think that that's equally important?
That's how the question has to be posed. Did you have any contact at all with individuals that you were barred from having contact with about the trial, about the jury deliberations over the last couple of days before this statement was found? Because then if anybody raises their hand or under oath says, yes, I did, then you can move for a mistrial. And really this comment was just the comment that opened up the door, Will, for the judge and the court system to be able to ask those questions directly.
That's right. And once again, the jurors aren't supposed to have any contact. They're not even really supposed to be out there saying, I'm a juror. Right. So to her point, even if any sort of interaction, if someone's asking you, how's the trial going, that could be a problematic situation because they're not supposed to be saying, hey, guess who I'm a juror for.